The petition for probate. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC559, the petition for probate to commence an estate and appoint a personal representative. SCAO for State Court Administrative Office, PC for Probate Court, 559 is the form number. You're welcome to contact our office. We'd be happy to provide one to you free of charge. Now, the petition for probate is the form used when opening an estate formally when somebody has died to begin the probate estate administration process. With all of the state court administrative order forms or state court administrative office forms, the statutes and court rules that give rise to the document are reflected at the bottom right corner of the form. You can see here from the floating arrow, there's quite a few statutes and court rules. With these court rules and statutes, there's a lot going on here, a lot of information. We're going to cover some of the basics here, but to really understand how to navigate through the probate process, to understand how to navigate through this particular petition, and whether this petition is even the right petition for your particular set of circumstances, please consult with an experienced, competent, well-versed probate practitioner who understands this area and knows how to navigate through these forms. It's not intuitive. It's not easy or obvious. And when you go to court to file these, the court doesn't help you or assist you in the completion of the forms. So again, this is step one of a multi-month process. It's complicated, not simple to do, and we strongly urge you to work with a skilled, competent probate lawyer. Let's work our way through the document and understand how this document works. Again, top left corner, identifying the county in which the decedent was domiciled. And if the decedent was domiciled out of the state of Michigan, but has assets in the state of Michigan, which gives warrant to the opportunity to commence in the state of Michigan, you'd identify that county there. So again, top left corner, the county in which the probate will be. In the middle section with the red rectangle, you're identifying whether the estate is testate with a will or intestate without a will. Again, language that just isn't intuitive to most people. Testate with a will, intestate without a will. The file number is left blank because the court is going to assign the file number when you file this and pay the requisite filing fee. A file number or case number will get assigned. As we work our way through this, at the top, you're going to identify the name of the decedent. Typically, this name will mirror what is reflected on the death certificate, but sometimes we use also known as. For example, if the person had different names that they were known as, you may want to include both of them here at the top line. The first is the identification of who the petitioner is. And under Michigan statutes, there are people that are interested and have the right or standing to file a petition for probate, to begin the probate process. I, for example, couldn't open up a probate estate of somebody that I have no connection or relationship under the statutes or court rules. So the statutes and court rules define that you have to be interested in the estate to make the petition. And there are various statutes and court rules that dictate whether you have an interest to be able to commence the probate estate. Again, the next section simply identifies what is your relationship to the decedent. Maybe you're the surviving spouse. Maybe you're nominated in the will as the personal representative. But again, that standing to be able to be the petitioner is defined under MCL 700.1105C, as well as other court rules. So again, understanding the standing and your right to file is really critical. The next section is some basic information. The decedent's date of death, time of death if known, date of birth, and the last four digits of the Social Security number. In addition, the domicile. Now, the word domicile can be confusing because we think often of residency. What happens if somebody has two domiciles? They live sometimes in Michigan, sometimes in Florida, and so on. So again, understanding domicile is an important consideration here, as well as the county and the state. Now, often this domicile needs to match the death certificate, or when you get to the probate counter, if there's a mismatch, it could cause some delay in getting your matter advanced through the probate counter for purposes of scheduling a hearing or getting a personal representative appointed. So again, domicile is an important word to understand. The next section identifies the approximate value of the estate. as well as the personal estate, real and personal. And this just gives the interested persons as well as the court some basic understanding of what is going through probate, what is the purpose of the probate, what assets may make up the probate estate. Often that information is just simply not known. So often people will just write the word unknown there. Now again, the statute requires when you file to show proof of death. So that can occur under Section 3 with either a death certificate or some proof of death if a death certificate is not available. That could be a coroner's statement or medical examiner. It may be an obituary, depending on the court's willingness to accept the filing based on proof of death. The next section is a really important section. It's an identification of the interested persons within the estate. And again, this section is often done incorrectly. You have to identify all the heirs and devisees. You have to identify all those that are entitled to notice under the court rules and statutes. So it's critical that you understand Michigan's prioritization and who has the right to notice of the commencement of a probate estate. You have to put their name down, their address, their relationship. Are they an heir? Are they a devotee? What is the relationship? Are they a minor? Are they an adult? And so on. Here, people often will make these weird decisions like, well, I haven't heard from this person in a long time, so I'm not going to include them. That's not how the statutes work. You have to include them, and then the court can take action if you have some basis for determining that they're not an heir under the statute or they don't have a right. But you don't get to make that decision. It's based on the statutes and court rules, and understanding who is an interested party is really a critical piece of the completion of this petition. Again, consult with an attorney before filling this piece out because you don't want to get yourself in trouble. You are signing this document under the penalties of perjury, so it's really important. The next section identifies whether any of those people are under a legal disability. Are they under guardianship, conservatorship? Do they have any special needs, developmental disabilities? Are they a minor? That's the section you'd identify what disability they may be under and who their legal representative would be. Section 5 identifies venue. We spoke about this a little bit earlier. If they're domiciled in the county at the date of death, that section is clicked. But if they're domiciled out of the state of Michigan, but they have an asset in that county, that would also be a relevant basis for venue. And then number 6 speaks about that an application was previously filed and a personal representative was appointed. So that's the informal process that would have been commenced by an application, and now you're seeking to do so by petition. Now with this petition, there's a front page and a back side. So let's work our way onto the back side of the petition. Item 7 indicates that a personal representative has already been appointed in a particular county. So again, if this has already occurred, you'd identify that the estate had already been opened at one point and that a personal representative has been appointed. Section 8 relates to wills and codicils. The decedent's will is being offered to probate and any codicil. Again, really critical section here. You have to identify whether there is a will or a testamentary document. You don't get to decide whether the will was proper or improper, whether you like the contents of the will or not. You simply must present it to the court for the court to make that determination. So you're identifying any wills and any codicils are being offered to the probate court and are either attached to the petition, or if it's already been filed with the court, you would identify that's already in the court's possession. Again, this is a requirement here. You don't get to make those decisions on your own. B and C speaks about whether there's an authenticated copy of the will, or C speaks if you can't have an authenticated copy, the will was destroyed or otherwise unavailable, but some contents may be available. You can ask the court under certain provisions of Michigan statute for that will to still be admitted to probate. So again, all the determinations about whether a will is proper, you're bringing it forth to the court for the court to determine whether the will should be admitted to probate. And again, some wills may not be perfectly executed, but this is the opportunity to advance it to the court for the court to make an adjudication of whether the person died with a validly executed will or died intestate. And again, with a will, the will is kind of the roadmap for distribution. Without a will, the state statutes determine the distribution based on the laws of intestacy. Number 9 says if the will had already been formally or informally probated. And then 10 says that, to the best of my knowledge, I believe that the instruments subject to the petition, if any, were validly executed and is or are the last will. And after exercising reasonable diligence, I am unaware of anything revoking that testamentary document. So again, when you advance a will, you have to identify whether there's been any revocation, cancellation of that testamentary document. Section 10A and 10B are pretty self-explanatory. Again, whether you are identifying any unrevoked testamentary instrument relating to the property as defined under that particular statute, 700.1301. Again, technical stuff here. You really have to understand the basis for this. And then 1301 also says that you're unaware of an unrevoked testamentary instrument relating to the property in the state, but the instrument is not being probated, and you can identify the basis or the reasons that it may not be appropriate. But again, I encourage you to follow that statute very closely to bring forth any of the testamentary or potential testamentary documents to the court for the court to make an adjudication. Section 11 is really the part that asks the court to identify and name a personal representative. So the priority of appointment is set forth by statute. For example, if somebody's nominated in the will, they have the highest order of priority as long as they're suitable and, of course, alive. And then there is a pecking order, a prioritization statute that dictates who has order based on their priority, based on if there's a will or no will, based on if they're the surviving spouse or children and so on, and how to deal with ties in the event, for example, the decedent died with no spouse, no will, and 4 children. 2 want one person, 2 want the other, or 3 want one person and 1 wants the other. How does the court make that decision based on the statutes? And again, these statutes give statutes and case law give an explanation of how to address those particular issues. 12 identifies if you're nominating somebody to be the personal representative in the petition, who are the people that have equal or higher order of priority, so that the court and the interested parties are aware that although you're seeking the appointment of one person, these people have equal or higher order of priority for appointment. 13 talks about whether the will addresses a bond, a surety bond, a guarantee of performance, as specifically mentioned or identified in the will. 14 talks about supervised administration as being directed in the will. 14b, again, these are about specific aspects of a will and whether the language in the will is directing certain things to occur, because the decedent who created this will is requesting a bond. Maybe they're requesting supervised administration and so on. And then, of course, if there's a need for a special personal representative for a particular purpose, again, there's an entire body of statutes that direct how a personal representative is appointed. Maybe there's a timing issue, that there's a statute of limitations coming up. There's some event that's going to mandate and warrant the appointment of a special personal representative before the full hearing occurs on the appointment of the personal representative. The next section is the request. This is what you're asking of the court. Again, a lot of repeats here. You're asking for the court to determine the heirs, and determination of heirs occurs even when there's a will, and that the person died either intestate or testate. You're asking the court, if there's a will, for that to be admitted. Formal appointment of the personal representative. Maybe there's a bond, maybe there's not a bond, whether there's supervised administration, whether there's a need for a special personal representative. Again, these are the requests of the judge, of the court, when you're filing this petition. So again, understanding what is the right request is really critical, because this is laying the foundation for many, many, many months of administration. You're going to be bound by these court orders that get put in place. This is a formal administration, not an informal probate, but a formal probate. So really being careful about assuring that you've got the proper request before the court and the proper order that will then get entered in letters of administration, letters of authority thereafter. Again, I mentioned that there's a penalty of perjury clause. You're certifying to the court when you sign the petition that it's been examined by you and that its contents are true to the best of your information, knowledge, and belief. So again, very important that you pay close attention to the language in that petition to understand what it means when you sign that document. A place for your signature, the petitioner's signature, the date, name and address, and if there's an attorney, the attorney's information on the left. Again, there's a lot going on here, and this is just one of the documents that you need when you file a petition, because you're going to still need your testimony and the other related pleadings as part of the larger package when you're filing a petition for probate. And I've also covered in other YouTube videos how to fill out those forms. But again, there's a lot going on here, a lot of statutes at play, a lot of court rules with many ramifications. At the Probate Pro, we're passionate about probate. If you have questions about the petition to commence a probate administration or any probate or trust related issue, visit us at the Probate Pro or call us at 1-833-PROBATE.